If it pleases the court, my name is Paul Bland. I'm here with my co-counsel Brian Warwick on behalf of the appellee. The separability doctrine, the idea that you look at the arbitration clause separate from the rest of the contract, the Buckeye argument, that does not apply to this appeal for a basic reason that the Supreme Court set out in the Granite Rock case 5 years later. The Supreme Court's differentiated between two types of arguments. There's formation arguments, by which they mean consent. Did the parties agree to arbitrate? That issue is always, and the word always comes from Justice Thomas's opinion in Granite Rock, a unanimous opinion. He said the issue of whether or not the parties agreed to arbitrate is always for the court. Now, when he's talking about formation, we're not talking about legitimacy, we're not talking about legality, we're not talking about fraud and the inducement, those sorts of things. All those are in the second category. So defenses to a contract, such as fraud and the inducement, the prima paint case, that's for the arbitrator to decide if it's against the entire contract. In the Buckeye case, which I handled and won in Florida and lost in the Supreme Court, we didn't have any argument that our clients had not agreed to the arbitration agreement. We didn't have a consent argument. Well, so instead what we did is we pointed out that the entire contract was illegal, and under Florida law, if you had a contract that was illegal, no provision would be upheld. But it wasn't an attack upon the entire contract. If the attack on the entire contract is about assent, however, it's in a different category. And in Granite Rock, again and again, if you read through the Granite Rock opinion closely, there's got to be about 6 separate times where Justice Thomas compares and contrasts the issue of agreement. Did the parties agree to arbitrate with other types of issues such as was involved in Buckeye? And he points out in footnote 1 in the Buckeye opinion, Justice Scalia put in the first footnote, we are not talking about cases where there's a question about whether the parties agreed. Now, Your Honor made an extremely important point when you said that these are documents that are signed contemporaneously. So what does Florida law say about when is a contract, when do parties agreed to something with a contemporaneous contract? Because one of the things that Justice Thomas makes very clear in Granite Rock is that when you're trying to decide whether the parties agreed to something, you're supposed to apply general, normal principles of state contract law. Now, if contract law is being distorted in some way that's hostile to arbitration, it's preempted. What the McKenzie and the Concepcion case say is that if contract law is being read in a way that makes it impossible for someone to have arbitration, or a core characteristic of arbitration, then it's preempted. But otherwise, with those two exceptions, so discrimination or conflict preemption, with those two exceptions, state contract law governs. So what's Florida state contract law here? In Duval Motor, I'm sorry,
and I appreciate your argument. So I didn't realize you were counsel in Buckeye, but in Buckeye then, which I believe that involved a contract based on the usury rate?
Yes, Your Honor.
And so in that case, you had a contract that was void against public policy.
Right.
You're saying that's in a totally different category because obviously the parties agreed to that contract, but under law, by operation of law, they couldn't agree. Whereas here, obviously you and the trial court found they didn't agree.
That's right.
Even though they signed an arbitration agreement.
Consent and assent are completely, and which is what the Supreme Court.
But let me ask you a follow-up then. So in this case, you have a contract that says, because you don't disagree, right, that the RPA was a contract before the RISC was signed.
Well, when you say before, let me be clear. I think that your colleague, Your Honors, is right to say that the key thing about these documents is they were signed contemporaneously. And what the law of Florida, which is pretty much general contract law everywhere, is where you have two documents that are signed contemporaneously. What you're supposed to do is you read them and construe them together and you reconcile them. So what did these contracts conclude? When you have two contemporaneous contracts, you read them both at the same time, and to figure out the intent of the parties, you look at the language of the contracts and you reconcile them using normal, traditional principles of contract law. So here, what this court said in Duval Motors, where I agree that the Federal Arbitration Act was not raised, but I don't think it matters, because what Duval Motors is about is what did the parties agree to? Did they agree to arbitration or not? And this court, applying general rules of Florida contract law that apply to all contracts, found that when you read these two documents together, contemporaneously, when they reconcile them, the integration clause governs. Now, this is not law that was made up for the purpose of being mean to arbitration clauses. The rule that integration clauses, it's been in Willison and Corbin and going back in the restatement for 200 years, and it's from the British, and it comes in, it's applied in 1,000 cases that have nothing to do with arbitration clauses. And moreover, the rule that integration clauses and the parole evidence rule that this court talked about in the Duval Motors case in no way brings in the Concepcion issue. And let me explain why Concepcion, because they cite that, and that is the last Florida Supreme Court decision on FAA preemption. It's the McKenzie case, and sorry to say I actually lost that case too. Justice Scalia has been very hard on my practice. But fortunately, Justice Thomas is totally with me in this case on the Granite Rock case, so I'm in luck. In the Concepcion case, California law said that if you had an arbitration clause that banned class actions and you had a small dollar value case, that the small dollar value, that the ban on class actions was always illegal because people wouldn't be able to go forward on a small dollar value case. And so what the Supreme Court said is that, look, there are certain core things of arbitration that you can't, no state law can interfere with. So, for example, the whole point of arbitration is to get rid of a jury trial. So if Florida had a rule that said you can't have jury trials for retail installment contracts, that would be preempted. If Florida had a rule that dealt with class actions, because Justice Scalia said that was a core element of arbitration. Here, is there anything that's core, that's central to arbitration that says you can only have the arbitration clause in the retail purchase order, but not in, or retail purchase agreement, but not in the risk? There's no core rule about that. Tons of car dealers in Florida and throughout the country have an arbitration clause in the retail installment contract. Nothing easier for this party to do if they want to bind people to an arbitration clause in the retail installment contract is to put one there. That's what most other companies do anyhow. What they're saying is that the normal rules of Florida contract law, the rules that say that when you sign documents contemporaneously at one time, that you then try to reconcile them and figure out what they mean, the contract rules dealing with integration and parole evidence that this court cited throughout the Duval Motors case are now preempted by the Federal Arbitration Act, even though there's no way distinguished because of the separability doctrine. My friend will be under enormous pressure to come up with a case where a court found that the parties had not consented, had not agreed to arbitration, and to find that there is a separability doctrine that applies and says that if you have no agreement, that you still enforce the arbitration clause and let the arbitrator decide. When you look at consent, which is the word that Justice Thomas uses at least a dozen times throughout the Granite Rock case, it might as well be the same as forgery cases or capacity cases. There is a difference between a capacity case and something like fraud in the inducement, for example, which is like the Solimore case that they cite. I'm not sure, I'm probably mangling the pronouncement, but the case from the 11th Circuit. So this is a case where these people were ripped off in the Madoff scam, and then afterwards, they're negotiating with the brokers who sold them the securities, and they come in and they say, we want to have a we want to work something out where you're going to pay us back, and they sign a first agreement that has an arbitration clause. And then they said, well, the only reason we signed that agreement was because we thought we were then going to sign this bigger agreement that was going to have a bunch of other provisions that protected us, and then the brokerage refused to sign the bigger agreement. In that case, their argument was not we didn't agree to arbitration. Their argument wasn't we didn't consent to arbitration. Their argument was we were defrauded. That's the Primate Paint case going back to 1967. It's a defense. There's a huge difference between assent at the outset, consent at the outset, and fraud in the inducement. Let me give you an example. Suppose, hypothetically, I were to sell to one of your honors a bunch of securities and say, I promise you that these will have a 100% rate of return. So I lied. I intentionally lied. I knew they would only have a 50% rate of return. So you keep the securities for 5 years and you get 50%, but you never get the 100%. Now, I fraudulently induced you into buying these securities. Do we have an agreement? It's up to you. Because you assented to the original agreement, then fraud in the inducement's a defense that comes up afterwards. You might well decide not to sue me for fraudulent inducement because you like the 50% return. You might decide that fraudulent inducement is something you're going to let go. That's different from an argument that says you never agreed to buy the securities in the first place.
Well, your argument is, essentially, we agreed to arbitrate, but then we agreed not to arbitrate. I see it. That's what this case comes down to. There's no question your clients agreed to arbitrate. I mean, that's just undisputable in my view, at least, because that's what the agreement says. Then at exactly the same time, essentially, a financing agreement is signed that doesn't deal with whether your client was going to buy the car. It deals with how your client's going to pay for the car. And in the financing agreement, yes, there's a merger clause, but all signed at the same time. I mean, granted that, you know, under our Duval Motors case, if that is deemed to be controlling, then you've got a prevailing argument there as far as contract formation goes. But there's no question that the retail agreement doesn't address arbitration. It didn't revoke an arbitration clause. It didn't address arbitration. It was silent on it, right?
I actually disagree.
You think the service agreement, the financing agreement, was not silent on arbitration?
I think that the integration clause had the effect, the way the integration
Was there a clause in there that said we're not going to arbitrate, any dispute's going to go to circuit court? I didn't see it.
What this court said in Duval Motors is that when you take these two documents signed contemporaneously and you reconcile them and you look at the contract language of the two documents to determine the party's intent, that this court found that the normal principles of Florida law are that the parties did not agree to arbitrate, that the integration clause operates as if it had said we have never agreed to arbitrate, that's the effect of the integration clause.
Your best support in your view is Granite Rock, right?
Absolutely, Your Honor.
I don't see from reading all the briefs that this question's been answered in a crystal clear fashion by the United States Supreme Court.
I think that
whether you have contemporaneously signed agreements,
right,
where it's obvious, I would submit to everybody in the room that this, I guess maybe perhaps I respectfully disagree. I'll certainly be considering your arguments, but it's obvious the second agreement does not address arbitration. It is a financing agreement regarding financial terms, truth in lending, all the federal laws that apply to those types of agreements because they're financing, the rate of interest, et cetera. It's silent on arbitration. Maybe you're right. Because it's silent, there's no agreement to arbitrate. I understand your argument. But contemporaneously signed contractual agreements, and then we have to say under federal law whether that first valid arbitration agreement is null and void because it no longer exists. I haven't seen that answered in those cases.
The Supreme Court has not faced the two contract situation. That's definitely right.
And you say it's common in the business.
It's common in the car business, yes. So I think that I cannot think of the 45 cases the Supreme Court's dealt with in the area of mandatory arbitration. None of them have come from a car setting. Quite frankly, there aren't that many they tend to come from cases involving American Express or AT&T or companies that pay different kinds of money for their appellate lawyers, to be honest. This could be the first one. I mean, I would love to have another case in the Supreme Court because I could use a win there, and I feel like with the Granite Rock case that it's pretty set up. Your Honor, the federal law issue is absolutely clear, that if there's an issue of assent to arbitrate, that is always an issue for the court. And Justice Thomas used the word always, and I stress that. I think, to be very blunt, Your Honor, I think that the argument you're making is that there's an agreement to arbitrate and the second document doesn't counter that.
Well, that's their argument.
Well, but that argument is counter to the Florida law answer under normal principles of contract law given in Duval Motors. I think that to say that the parties here agree. Your argument is the fact that the FAA is not discussed in Duval Motors is irrelevant. Because this is resolved by contract law. Because it's resolved by the part of contract law that deals with consent. If this involved any other aspect of contract law, if I was up here trying to sell you illegality, fraud in the inducement, any defense, then I would be without a paddle in the water. But because I am saying that the parties did not agree, when you read these documents contemporaneously, which Your Honor correctly points out is the proper metric, Florida law on the question in this district court of appeal, Florida law about what did the parties intend to consent to when you read these documents contemporaneously, when you reconcile them, The intention is that there was no consent to arbitrate, and the normal contract rules that go to assent govern there. And
Could I ask you one question before your time runs out? What if your clients wanted arbitration and they said, well, when we were told that the arbitration clause applies here, and would that be a fraud case then? And who would decide whether it's enforceable?
Then it
I'll
would be,
give you
that
two
would
more, excuse me. Please give the appellee 2 more minutes and the appellant 2 more minutes. Thank you.
Thank you very much, Your Honor. Because the law is clear in this district that there's no assent to the arbitration clause when you reconcile these two documents, our clients would then be trying to argue that they're stopped into arbitration through fraud. That would be an issue for the arbitrator, because that would be prima paint, or that would be the Solomar case, the Madoff case from the 11th Circuit.
You're arguing essentially an affirmative defense is for the arbitrator, consents for the trial court.
That's right. And Justice Thomas, it's the page of the opinion where he says that issues of assent are always for the court is on 2856 of the opinion of the Supreme Court decision. I mean, he makes this point in different ways. It's a somewhat repetitive opinion. He makes this point about, literally between half a dozen and a dozen times. But that's the part where he used the word always, which is my favorite word in the opinion. Thank you, Your Honor.